Your Honor, I guess last is least. I will take to heart your admonition not to repeat what has been said before. What I would like to address are issues which have not been discussed by my co-counsel, as well as to answer some of the questions that the court has had. I think on the original question that you had posed regarding a remand on whether or not there's been substantial impairment, our position in our brief has been that you can remand on that issue. I believe that the contract clause analysis is three-step, and I think that Your Honor was discussing if you've addressed and resolved the first step, if there is a contract, what do you do next? Of course, the test is whether the impairment was substantial and whether the impairment was, in so many words, justified. And I believe that those matters can be remanded to the court because they arguably, well, certainly are fact-based. And this court did not reach any facts or made any fact findings at all. Now, Your Honor, I'm, again, going to try to avoid any repetition. But Your Honor also made a comment earlier about the IRS and whether or not the real impetus for 9.5 was to comply with the IRS. I'm not sure if there's a misunderstanding on the part of the court. There was IRS litigation and a settlement and legislation back in, I believe it was either 1992 or 1994, when the state took assets out of one of the pension funds, and the IRS came in and said, you cannot do that. And as a result of that, there was legislation basically required by the IRS. There was state legislation which essentially provided that the state will not do that. I'm sorry, Your Honor. And I think that that is the only substantive IRS statute or provision that I can recall. And believe me, I've been involved in litigation and pension system since 1994. And if there was any subsequent dealing with the IRS laws, it was generally to ensure that the benefits would not exceed the statutory amount allowed by the pension, by the IRS laws. That is normal and, in a sense, pro forma in many of the pension laws, that there simply be a guarantee that it not violate any IRS laws. But I can tell you from my involvement, from 1994, when the NJEA and CWA challenged the various machinations that were made by the legislature in the pension system, such as changing the interest rate or the assumed salary increases for teachers and other public employees at a certain rate, and then assuming the rate of return at a much higher rate in doing fresh starts where they would, normally the actuarial method looks back 5 years, so there's a smoothing, but the state had a tendency to choose a year that had a very high return, so the market was high, and they would go back and choose that. They did that in 2001, by the way, when they looked back to 1999, in the middle of a smoothing period, because 1999 was a very high market. So the suit was basically based on those types of activity. That suit, in essence, resulted in the 1997 legislation. And that suit ended up with two forms of the legislation, if you will. One was the Bond Act, and the other was the protections sought by the unions and by public employees. And the appellate division, this court, in the NJEA matter, which was also a case which we handled, pointed that out when it noted that in 1997 there were two bills that were presented to the legislature. One represented the theory that the way to protect benefits was to make sure that they were funded. The other, to protect benefits, was to provide a contractual right to protect the benefit and to leave it to the state how to fund it, whether to fund it, so long as the benefit was paid. Those were the two theories, and the court, in this court, recognizes them. The legislature made a decision. It chose to protect the benefit, and it left the funding to itself. So the decision in the NJEA case, the issue of the right, the benefit, the right to the benefit is not dicta. It is part and parcel of the legislative decision that the funding is not contractual, but that the benefit was. That was the decision that the legislature made in 1997. That was its choice, and the language in the NJEA case dealing with that distinction is not dicta. It goes to the essence of the 1997 law. Now, I'm not sure whether, I've learned over these many years that questions by the court and hypotheticals by the court do not mean that that is what the court is going to decide. And I know that you expressed the hypothetical that we're assuming it's a contract, if for no other reason than the Attorney General and the Office of Legislative Services have both opined in opinions that were submitted to the legislature that this is a contractual right. If you also look at the U.S. Supreme Court cases where they found that there was a contractual right in the U.S. trust case, they did it largely based on the word covenant. They did not require the word contract. And in, I believe it's another, I think it was a First Circuit case, a more recent one. I think it's Perillo, which we've cited. Yeah, I think it's 173, Fed 3rd, 46. There, the court finds another important indicia of contract, that the statute provides for a prohibition or a protection against reduction of benefit. That was also indicative of a contractual right. Now, I'm not going to go through all of the other, the word non-forfeitable means a legally enforceable right.
I think we understand that.
Okay. I just wanted to make sure that the hypothetical was not merely a hypothetical.
We understand you. Anything further?
Well, I would like to address two other issues raised by the Attorney General in its brief that have not been addressed here this morning. One is the argument that they made that the law regarding contracts requires specificity, and that there's no specificity regarding the COLA. Now, this is not necessarily a contract. They seem to be acknowledging that the right to the benefits program is a contract, but they're using this specificity requirement to say that the COLA is not part of that contract. That's in their brief. But what's interesting are the cases that they cite. For example, I think it's General Motors versus Romaine. A fascinating case. The U.S. Supreme Court decided that, which is one of the specificity cases. In that case, what the state legislature did was say to employers that when you're paying workers' comp benefits, you can now deduct from that other sources of income that the employee is receiving, such as disability payments. And because of a court decision, the employers applied that retroactively. The legislature then said, no, you cannot do it retroactively, and the employers sued, saying that, wait a second, that is a contractual right because it was in the law. The court rejected that, not because there were collective bargaining agreements in effect, and that was the contractual issue. And the employers were arguing that the right to retroactively apply the other sources of income and deduct them was because it was a law, therefore it was deemed to be implicitly in the collective bargaining agreement. And the court said, no. Not because the collective bargaining agreement itself spelled out these specific terms, but because the court said we're not going to implicitly impose into a contract or hold that it's part of the contract every single statute that the legislature enacts. It was not a specificity argument over what was in the contract. It was simply that we're not going to add legislation into each contract.
I think we understand.
And
Do
similar.
you have another point you want to go on?
Okay. Your Honor, on the issue of reduction, they're making the argument that there's no reduction here. Now, I would say that, Your Honor, we have all cited cases from around the country. And clearly the courts have gone different ways on this. Generally, or frequently, based on particular words in the statute, such as the main decision that was recently submitted to the court was based on the fact that the COLA statute that the contractual right to the pension excluded the COLA. So therefore, the court said the COLA is not protected against reduction. But let's view the term reduction for purposes of our statute. They're saying that there's no reduction because we're not taking it back. But the essence of the COLA is to maintain the underlying retirement allowance in essentially current dollars. If that is the purpose, and that is certainly what the legislature said when they enacted it in 1958, if the purpose is to maintain the underlying pension in current dollars, then the elimination of the COLA means that the underlying benefit will be reduced. That is the
We
reduction.
understand the argument, yes.
Okay. Your Honor, I would also just like to note, again, I'm not going to go on to other areas, clearly the court has heard anything. I would just like to note that we recently found the Arizona case.
And you can provide us with that.
We've just found it. If not,
We just found it, I think, well, we're gonna ask for some additional briefing. Anyway, you can provide it. It's not fair to your adversary to sort of present it for the first time now.
I would only have cited it, Your Honor.
That's okay. All right, I think we understand your argument. We appreciate that. And,